Navigating layoffs as an H-1B worker. That's what we're talking about on today's episode of Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. I'm so glad that you have joined us, whether you're joining us live or whether you're catching the replay. If you have questions about this topic or any other topic relating to family-based or employment-based immigration law, feel free to drop those in the comments. I will respond if I can. Keep in mind, none of this information is legal advice. It's educational purposes only, and I can't give legal advice in this particular forum, but feel free to put your questions there and I will help to the extent that I can. So let's talk about navigating layoffs if you are an H-1B worker. In our previous video last week, we talked about the employer's perspective, navigating layoffs from the employer's perspective, how to handle that if you have to terminate an H-1B worker's employment early. Today, we're talking about it from the H-1B worker's perspective. So you do have options. If there's one thing I want you to take away from this, I want you to know that it absolutely, yes, is a stressful situation. Anytime a person loses their job, it's a stressful situation. Add on top of that the additional complex layer of immigration. And it is, I can't imagine, I haven't been in that position myself because I haven't been an immigrant or a foreign national, but I can imagine it is incredibly stressful and it just adds another layer of complexity over an already stressful situation. But what I want you to take away from this is that there are options. You are not immediately out of status in most situations if you are laid off and if you're in H-1B status. So why not? Why is that? The main reason that that is usually not the case is that there is something called a 60-day grace period. The 60-day grace period is discretionary, so it is possible that USCIS would not adhere to this, but so far we're seeing, knock on wood, we're seeing that they are. So the 60-day grace period is, as the name implies, a grace period of 60 days that starts immediately following your termination. USCIS has set in guidance that they define the last day of employment as the last day for which you're paid. So if you work until, let's say, May 1st of 2025, just making this up, and your last date of payment is also May 1st, that would be your last day of employment, and your 60-day grace period would be start May 2nd of 2025. Keep in mind, your 60-day grace period only applies once. So if you've used it before during this petition validity, you probably cannot use it again. Make sure that you consult with an immigration attorney if you are in that particular situation. And keep in mind that the 60-day grace period only applies if your I-94 is not expiring within that time frame. So in other words, the 60-day grace period is a grace period of 60 days or until your I-94 expires, whichever is sooner. So if, for example, your last day of employment was May 1st of 2025 and your I-94 expires June 16th of 2025, that's when your grace period ends, June 16th of 2025. You don't have the full 60-day grace period. So there may be some situations in which you have less than 60 days, but in general, you have a 60-day grace period. So what can you do during this grace period? First of all, I fully recognize that a 60-day grace period really is not that long. If you've been laid off, especially if it's unexpected, then I know it's not that long of a period, but it's something. So during this 60-day grace period, you can, of course, look for another job. You can remain in the United States as long as that 60-day grace period applies. You have the option of, during that time frame, filing another H-1B petition, or having a new employer rather file an H-1B transfer petition for you, or changing status to another visa classification, which we'll talk about in just a minute, or potentially leaving the United States. Personally, I hope that you don't do that. I hope you're able to find a way to stay in the United States. I think foreign nationals add so much to our country just as people, as individuals. So I hope that that's not what happens, but that is a possibility. What you cannot do during that 60-day grace period is work. If you have not filed an H-1B transfer for a new employer, you're not authorized to work during that 60-day grace period. So that is something to keep in mind. Just checking my notes to make sure I'm covering everything here. So let's go back to the things that you can do during the 60-day grace period. I said that you can, of course, look for another job. of course, I'm sure that in most cases that's what you're going to be doing. If and when you have another job offer, and if the employer is willing to sponsor you for the H-1B, that employer will file what's called an H-1B transfer petition. That means that they're filing a petition to transfer your H-1B petition from your previous employer to this new employment. There is something called H-1B portability, which is pretty cool. It means that as long as you meet certain requirements, when USCIS receives the H-1B transfer petition, you can begin working for the new employer. So that also applies within the 60-day grace period. You have to file within the 60-day grace period. If for whatever reason you file outside of that grace period, H-1B portability would not apply. So make sure that you're talking to Immigration Counsel before you rely on it. But with H-1B portability, you can begin working as soon as USCIS receives that H-1B transfer petition, which is amazing. So that's one thing that you can do. If you do not have secure employment during the 60-day grace period, you also have the option of changing status to another visa classification. So sometimes employees or H-1B workers will change status to B1, B2, which is a visitor's visa status, to allow them to stay in the United States for a longer period of time, either to continue looking for a job or to wrap up affairs. So that's one possibility. If you change status to B1, B2, so you file that petition during the 60-day grace period so that you're able to stay in the United States, then you are, like I said, you're able to stay in the United States. Then you find a job. Let's say that you find a job, an H-1B, an employer who's willing to file an H-1B petition for you. Then make sure you talk to your immigration lawyer about that situation, right? Because you don't want a situation where the H-1B petition is approved and then subsequently the change of status to B1, B2 is approved. That probably won't happen depending on the timing of your particular situation, but please make sure that you're having that conversation with your immigration lawyer or your employer so that they are able to work with you and come up with a strategy for the timing. Most likely, USCIS would want to see that change of status to B1, B2 is approved anyway, before the change of status to H-1B is. I'm getting into the weeds, but my point is, if you have filed something, make sure you have that conversation that you tell the immigration lawyer working on your case or your employer. That's something that we always ask whenever one of our corporate clients has an H-1B transfer. That's one of the questions that we ask. We ask, what was the last day of employment? Because we want to know when that 60-day grace, if that 60-day grace period is in play, and if so, how long we have left. And of course, if they have filed anything in the intervening time period, because we need to know about that so that we can come up with an appropriate strategy for them. But that is a possibility to file a change of status to something like B1, B2, at least temporarily. Another option potentially is to change status to F1. Something like F1. You can change status to any number potentially of different visa classifications, but sometimes a person will change status to F1, which is a student visa. That means you have to study in the United States. It means you have to enroll in a program, have that change of status approved, pay certain fees, including the tuition to the university, and be in full-time student status, meaning attending school full-time. But that might be a way to stay in the United States. Again, talk with an immigration lawyer before you take any particular action, but that is an option that some people consider. Another option might be, depending on your situation, to change status to a dependent visa. So sometimes our clients have spouses who are here in the United States on an H-1B themselves, and they're still working, or perhaps they're here on an L1 or another visa classification like an E, for example, and they are able to work. They, meaning the person who's laid off, is able to change status to that dependent visa classification. Depending on the visa classification and depending on the facts, you may actually be able to work. So for example, if your spouse is here on L1A or L1B, the L2, which is the dependent status, is work authorized in the United States. Same thing for the spouse of somebody here on J or E, they are work authorized here in the United States. That's not true of every visa classification, including H-1B in certain situations. So if you are in H-1B status, your spouse is in H-1B status, and you decide to change status to H-4, which is the dependent classification, you may be eligible for work authorization if your spouse has the I-140 petition approved and you have to apply for the employment authorization document. So know that while changing status to a dependent visa classification may be a good short to medium term solution, it may or may not be a good long-term solution, depending on whether you're work authorized and if that's important to you. One final thing that I want to touch on, not to scare anyone, but to be realistic, right? We're in difficult times as far as immigration law goes right now. And we have heard reports, I have heard reports. I'm friends with a lot of different immigration attorneys around the country, and I'm in different networks of immigration attorneys around the country just to keep my ear to the ground and have some idea of what's going on. And we have heard reports of individuals who have been terminated from their H-1B employers receiving NTAs. That stands for the notice to appear. That's the first document that is sent to initiate removal proceedings or deportation proceedings. That is drastic, draconian. In my opinion, absolutely should not be happening. And I don't handle removal defense, so I'm not able to speak extensively on that. I can say that if I had a situation where a client received a notice to appear, of course, we would refer them out to a trusted colleague or colleagues who have extensive experience with that. But I want you to know that A, that's not happening, that it is happening. I want you to know that it is happening, that we have had trusted sources say that that's happening, that has happened to their clients, but it's not happening in every single instance. So yes, it's something to be aware of. At this point, I don't really know of anything that you can do proactively, except, as to the extent that you can, make sure that you are, finding other employment or changing status as soon as you can. That may or may not be helpful depending on the situation. If you receive a notice to appear, but know that it's happening, but also take a deep breath. It's not happening in every single circumstance, and the best that you can do is the best that you can do. And we are here to support you, whether that means us supporting you and helping you with a specific case, or helping you find a trusted colleague who can help you through that process. So take a deep breath. And I know that's easy for me to say because I'm not directly affected, but our clients potentially are, and I really do care. So just take that information as you will. And like I said, breathe as deeply as you can. But no, like I said, the main takeaway that I want you to have from this conversation about navigating H-1B layoffs is that there are options and that it does not have to be something that you do immediately. You, in general, will have that 60-day grace period, hopefully, or at least a period of grace period where you can think about your options and intentionally take some next steps. I hope that you have found this information helpful. If so, I hope you'll share this video with a friend or colleague. Make sure that you have subscribed to this channel so that you don't miss our next video. I would love for you to like this or comment on it so that it can reach even more people. My name is Emily Sumner with Sumner Immigration Law. We assist clients with family-based and employment-based matters around the United States and around the world. If you have questions, put those in the comments, and we look forward to hearing from you. Until next time.